Let's discuss about characterization under private international law. It's one of the most important concepts to understand and appreciate the subject. Let's start with when we require characterization. Obviously, whenever there is a conflict of law, we need to apply characterization. So this means that whenever a foreign element is present in the case and the court has decided that it is going to take up the case, that is, the court has decided it is having jurisdiction, then characterization needs to be applied. Characterization is also called as qualification under French law and classification under English law. In India, we simply call it as characterization. So we know when to apply it. Next, we need to know why to apply it. Why is there a need for characterization? Let's take a few examples to understand this much better. Let's start with an example of a Nepali woman who has died intestate and she is having two husbands. Both the husbands are legally married to her. It is a polyandrous relationship, and through those husbands, she is having three children. Let us suppose she is also having properties both in Nepal as well as in India. As far as Nepal is concerned, polyandry, let us suppose she is a tribal woman and therefore it is recognized. And therefore, both the husbands as well as the children will get a share of the property since she has died intestate without writing a will. As far as India is concerned, polyandry is not actually recognized under any of the Indian laws. Therefore, a conundrum arises. This woman is married in Nepal. She has lived in Nepal for a long time. That is a matrimonial residence, and that marriage is recognized in Nepal. As far as India is concerned, the Indian courts cannot say that it is not having jurisdiction to determine the validity of the marriage because properties are present in India. If the marriage is valid, it means that the properties need to be shared between the husband and the children, both husbands as well as the three children. Five people will get a share of the pie, to say it metaphorically. And if the Indian court is deciding that the marriage is not valid, then the properties perhaps would go to her siblings, those who were born along with her. Now, the Indian court cannot refuse jurisdiction, the property lies in India. It has to therefore decide whether to apply the Indian law or the Nepali law to determine the validity of the two marriages that she is having simultaneously. For determining whether to apply the Nepalese law or to apply the Hindu law, we need characterization to happen. Let's take it another scenario. An Indian Muslim man, he is having his citizenship in India and his domicile in India. He gets married to a German woman who is having her domicile and citizenship in Germany. Now, this is a polygamous marriage. Let's suppose this woman is his second wife. Can this woman on a later date claim that this is a bigamy, therefore the marriage is void ab initio in the Indian courts or in the German courts? No matter where the case is being filed, the first question that the court will be determining is whether it is having jurisdiction. As soon as the court decides it is having jurisdiction, the next question is, do I recognize this as a valid marriage or is it void ab initio? In essence, it means that do I apply the Indian law to determine the legality of the marriage or do I apply the German law to determine the legality of the marriage? Again, there is a requirement for characterization. Let's take two case laws from England to understand and appreciate this in a better way. A Hyde versus Hyde case which belongs to 1866, wherein the court said that polygamous unions are not at all treated as marriages, therefore we will not grant any matrimonial reliefs. And the Baindail versus Baindail case of 1946, wherein the court completely changed its stance and said that we recognize polygamous marriages, therefore we are ready to annul the second marriage. What's the difference between the two? In the first scenario, the concept, even though subtle, is very important. In the first scenario, the court is saying that if a particular law allows or if a particular religion allows for more than one marriage to happen, that is not treated as marriage under English law, which means that a Muslim man marrying only one woman is also not treated as marriage under English laws and English code because the Muslim man is having a capacity to get married to a second wife, a third wife. The marriage permits polygamy, therefore, that institution of marriage is not recognized in England. Whereas in the second scenario, the court is saying that we do recognize polygamous marriages, which means that the Muslim man getting married for the first time is legal and valid under English law. If he gets married for the second time or a third time, that marriage will be treated as polygamous or bigamous in nature, And the second marriage, third marriage, all those marriages, we will call it as void ab initio and we will annul the marriage. Now, characterization. In characterization, there are finer subtleties that we need to look into. Let's take it another scenario. An Indian man entering into a contract with a French man in France without any consideration. As far as Indian law is concerned, it is very clear. It's section 25 of Indian contract that clearly states that a contract without consideration is void ab initio. It is void. You cannot enforce it in any court of law. Whereas in France, a contract without consideration is also valid. Now, the contract has been entered in France. In case of breach of contract, the Frenchman, if he wants to file a case in Indian court, simply because the other party is an Indian citizen and he is having his properties in India, his business in India, if he wants to file a case in India, and the Indian court decides that the Indian court is having jurisdiction, then, in such circumstances, the court needs to decide whether to apply the French law to determine the validity of the contract or to apply the Indian law and say that the contract is void ab initio. In essence, characterization is required. Let's take yet another example. An Englishman enters into a contract with a French lady for marrying her. Now, this is legally valid both in England as well as in France. But if the man then decides not to honor the contract, it results in breach of contract as far as England is concerned and a tortious liability as far as France is concerned. Depending upon where the case is being filed, characterization needs to happen and it needs to be determined whether it is treated as breach of contract or a tortious liability. Remember that the remedies available for breach of contract is different from that of the remedies available for tortious liability. A good example as far as India is concerned with respect to conflict between laws is with respect to that of defamation. Defamation is treated both as a crime under IPC section 499 or in the present day scenario, Bharatiya Nyaya Samhita section 356 classifies it as a crime. At the same time, it is also treated as a tortious liability. So you can opt for a civil suit or for a criminal suit depending upon what kind of remedy you are asking for. So in each of these scenarios, you can very clearly see that characterization is very, very essential. So as soon as the court determines it is having jurisdiction, it needs to determine whether the factual situation is giving rise to any legal relation. If the legal relation is there, then it needs to determine what kind of rights and obligation it is creating. Without this specific characterization, the court cannot move on to the next step. What do I mean by that? A French man and an Indian man entering a contract. Only if the contract is valid, only if the legal relationship exists, then there arises a question of rights and obligations. So, to determine whether the legal relationship exists, should I be applying the French law or the Indian law? That is characterization. Similarly, Hyde versus Hyde case and Baindail versus Baindail case. Is there a marriage there in existence? Which requires in turn a question, which law should I be applying? Should I be applying the Islamic law or should I be applying the UK based civil matrimonial laws? Only if I decide whether the marriage is there in existence, I can decide whether it can be annulled or it can be turned into that of a divorce or a restitution of conjugal rights. So this determination of existence of legal relation, that is what is characterization. So should I be applying my country's law, some other country's law to identify whether there is a legal relationship? That is the essence of the question. Without this characterization, the court obviously cannot take the next step. Now, as far as laws are also concerned, laws actually fall under two categories, right? The procedural law and the substantive law. What is procedural law? What is substantive law? That also differs from country to country. So when I was talking about identifying the legal relationship and then applying the rights and obligations in each case, the rights and obligation actually fall under substantive law. Now, this rights and obligations, the substantive law, what constitutes substantive law also differs from country to country. For example, statute of fraud or what we call as registration laws in India and in England is treated as procedural in nature. Whereas in Germany and France, it is treated as substantive in nature, which in essence means that The court is not only determining the nature of a particular legal relationship. When the question comes to application of a law, if you are going to apply a law, it needs to be substantive law as far as foreign countries' laws are concerned. Procedural laws, only the law of the foreign will be applied. For example, in India, only the Indian registration laws will be applied. You cannot apply the German or French registration laws in India. We apply only procedural laws of India in the Indian courts. So classification of law also equally matters in delivery of justice. Characterization of the laws that we are going to apply also matters. Even if a foreign element is present, procedural laws of India alone will be applied in the Indian forum. The same rule applies for each and every country. Another example of this scenario is marriage of a minor. In England, it is treated as procedural aspect, therefore only English laws will be applied as far as validity of marriage of a minor is being determined. Whereas in France, it is treated as substantive in nature. Similarly, certain actions are treated as valid or not valid depending upon the different nations. Marriage by proxy is valid, legally valid in Pakistan, Argentina, in certain parts of USA, such as Texas, Colorado. Whereas it is not valid under Hindu laws, Christian laws, German laws. So, determination of the nature of law also is very, very important part of characterization. As far as characterization is concerned, we divided it into three different stages, stage 1, 2, and 3. Each of these stages help us determine which law to apply and what will be the final judgment. In case you require a step-by-step analysis of why characterization is required with help of a case law, I have done the same in the Farah versus Farah case. The link for the video is given in the description below. You can click on it and have a go at it. Each of the stages of characterization needs in-depth analysis, and we will be taking it up in our further videos. If you found my video informative, kindly like, share, and subscribe to my channel. In case you have any doubt, write it in the comment section and I will help you out. Thank you. Have a good day.